All right, so look at those videos admitted into evidence. They'll show them in a minute. But first, I want to bring in my guest for this hour. Joining us to discuss from Santa Fe, New Mexico, criminal defense attorney John Day. John, great to see you. Thank you so much for joining me on the program. And, you know, one of the things that the state said going into this case and during their opening statements was, and I quote, "This is not about holding a parent responsible for the acts of a crime. They are for his acts." But I say this. If it walks like a duck and quacks like a duck, it's a duck. And that's exactly what they're doing. That's my thoughts. I'd love to get your thoughts on this case.
Yeah, that's a good description. I mean, we're seeing more and more of this where local district attorneys are trying to hold parents responsible when they make these overt decisions to, as in this case, the allegation is you give the son a gun, you give the son a gun that can cause lots of damage, and you give the son a gun when you have knowledge. You know what his situation is, what his issues are. You know, in this case, for example, the allegation is that the son was obsessed with school shooters and essentially had that on his mind all the time. And so it's like throwing a match onto gasoline, according to the prosecution. You know something bad is going to happen. And they are holding the parents responsible because, in their view, the parents made a reckless decision. The father made a reckless choice.
You know, this is an interesting case because they're getting to that murder. They've charged him with second-degree murder in this case. He's also, in the case of the older victims, being charged with involuntary manslaughter. But this second-degree murder charge basically comes from the cruelty to children charge, where they have to show that he was criminally negligent, and that criminal negligence causes the death of a child. That's a conviction of cruelty to children. If a child dies, then that can be raised to second-degree murder. Now, the causation is the issue here. They have to show that he knew that this is something that his son would do. I think that makes it more difficult here than the case we saw in Michigan, where there was known or should have known. That doesn't sound like that's one of the issues here in Georgia. They have to show that he knew that what was going on in his son's life was going to lead. It was foreseeable that he would do this.
Right, and that's the key. That is the difference in the Michigan case. But again, the idea that the parent, the father in this case, had so much knowledge, had so much information about his son's not just interests, but obsession with school shooters. And the idea that when you give someone like that a gun, and not just a pistol or a shotgun, it's a gun that has the capacity to do incredible damage. And apparently the father, allegedly, bought him a higher capacity magazine. So when you have all those facts together, it really does raise it to a different level than the Michigan shooting where the parents were held responsible. It shows that there was something that took it beyond that, some involvement, some knowledge that the parent had, that if they had just acted responsibly, these lives would have been saved.
Yeah, again, there's so many sort of parallels to that Crumbly case in Michigan. But one of the differences is I think this particular father seemed to be more involved. I think one of the issues in Michigan was that they seemed to be apathetic about what was going on with their son. Here, at least according to the defense's opening, he was much more involved in trying to get his son help. Even the gun was part of his approach to sort of bridging the gap between he and his son. All right, John, stand by. I do have to take a break. When we come back, we'll go back to that courtroom in Georgia. Keep it here on Court TV, your front row seat to justice. All right. Still with us, criminal defense attorney John Day. John, what is the defense doing? These first two witnesses clearly are sort of laying out, you know, the scene leading up to the shooting. With the first witness, they wanted to talk about how many entrances there were, how the students could enter, etc. Here, the only question they asked this witness was there were no metal detectors. What is the defense doing with their cross of these types of witnesses?
Well, they're trying to establish that, you know, there's certainly different avenues that could have gone down, that the father's not the only one who's responsible. They're basically trying to get somebody on the jury to think, you know, maybe he's not the one who's responsible for this. Maybe, you know, we ought to put the blame on his son, on the shooter, but it's not fair to place the entire responsibility on the father. They're just hoping that somebody on the jury is going to say, this is going too far. It's one thing to make the 14-year-old responsible, but to impute that blame to the father is just too much for us. So they're hoping that someone buys into that argument.
A big part of the prosecution's case is, you know, they talked about this is not about holding a parent responsible for the acts of a child. I would imagine the first 3 to 4 days are going to be about nothing but the acts of the child. They're going to talk all about what this boy did. Talk to me about that and how important that is for the prosecution's case.
Well, the prosecution has to try that case now. And again, the shooter's case has been postponed, apparently due to some psychological evaluation, mental health evaluations, but the father's going first, and so the prosecution has basically two bites of the apple. They get to try their case on the father's case, and then they get to go back on the shooter's case. But they do have to establish all the elements essentially on this trial, so they can try to hold the father responsible vicariously.
Yeah, no doubt, and that will certainly have an emotional effect on this jury, for sure. All right, John Day, thank you so much for joining me this past hour. Truly appreciate it.